Hey guys, welcome back to today's video. In this one, we're diving into a fascinating courtroom moment featuring a sovereign citizen who starts off confidently sticking to the usual scripted lines, but the moment the judge makes even a slight deviation, everything unravels. What follows is a mix of hesitation, stuttering, and complete silence that really shows how fragile that approach can be under pressure. Trust me, this is one of those clips you don't want to miss. Let's get right into it.
The court now calls the case of Kenneth Phelan, 26M23. Mr. Phelan, if you want to come forward. Mr. Phelan is here in person in the courtroom. Thank you for being here today. Mr. Shield is here in person on behalf of the prosecution. I'll find good cause, or I don't need to find good cause. Mr. Phelan, did you understand the rights that you have that I explained earlier?
I'm here under threatened arrest from the state of Colorado, and I retain all of my rights.
Okay, so I'm assuming since you're retaining your rights that you understand what your rights are, correct? All right. In your case, you're charged with a petty offense of third degree trespass. If you were to plead guilty or be found guilty of this offense, you could be ordered to serve up to 10 days in jail and pay a fine of up to $300. Do you understand the charge that you are accused of?
No.
What about that charge do you not understand?
To the U.S. Constitution, I'm allowed to go into, well, I have a right to petition the government, and so I don't understand how this charge is lawful.
Okay, well, you're accused of this. Nobody's finding you guilty. If you believe that you have a legal defense, you can say that you're not guilty and request a trial and require that the prosecution prove the charge beyond a reasonable doubt before you could be convicted or found guilty. But right now, I'm just telling you what you're accused of. Do you understand what you're accused of?
Not guilty.
Okay. You're moving steps ahead before my question is, do you understand what you're accused of?
No.
What about the accusation do you not understand? I understand that you think you're not guilty, but in order to think you're not guilty, you have to understand the accusation. By saying that you're not guilty, that implies that you understand what you're accused of, because you couldn't say that you're not guilty if you didn't understand it. So do you understand what you're accused of?
I am in standing of being that this charge is frivolous and malicious.
Okay, so you can plead not guilty and seek to require that the district attorney prove the charge beyond a reasonable doubt and that the charge isn't frivolous or malicious, which isn't a defense, by the way. I am going to interpret your response as you understand what you're accused of, because you're telling me that you're not guilty of it and that the charge is frivolous and malicious. You couldn't say that the charge was that you think it's frivolous or malicious if you didn't understand what it was. So I'm interpreting your response to mean that you understand what you're accused of. The next step in this process is I have to issue a thing called a mandatory protection order. So at this time, I'm ordering that you may not harass, molest, intimidate, retaliate against, or tamper with any of the people who are witnesses or victims of the act that you are alleged to have committed. Okay?
And I still have the right to face my accuser, is that correct?
You do. You're not allowed to harass, molest, intimidate, retaliate against, or tamper with them, though.
So in the state, so the U.S. Constitution says that the state is not allowed to charge a citizen without the jurisdiction of the Supreme Court. And this, and I understand that this is the state of Colorado charging a person of the United States.
He's just as misguided as the last one, because Article 3, Section 2 of the U.S. Constitution, the very provision sovereign citizens love to cite, actually says something quite different from what they claim. It makes clear that the Supreme Court of the United States only has original jurisdiction in very limited situations, like disputes between states or certain cases involving diplomats, not ordinary criminal matters. And as established in Cohens versus Virginia, the court typically only hears criminal cases on appeal after state courts have already ruled, especially when someone claims their constitutional rights were violated. In other words, cases like this must begin in the state court where the issue occurred exactly where he's standing now.
And so the the jurisdiction is led to the Supreme Court, and I do not.
You're not making sense.
I don't think
the
that
court
there's any
has
witnesses.
jurisdiction.
I don't believe there's any witnesses, or can we?
You might think that there's no witnesses, and there might be no witnesses, but if there are, you can't harass, molest, intimidate, or retaliate against them.
And
okay?
Can we set a date for discovery, or?
So if you need information about how to get the discovery in the case, you would need to contact the office of the district attorney. I don't have any discovery in the case. I have no police reports. I don't get any of that. If you want any of that information, you have to get it from the district attorney's office. I believe that they have a form that you have to fill out that tells them where you want them to send that information, and then they'll send it to you. Okay? So right now, you can't harass, molest, intimidate, retaliate against, or tamper with any witness or victim of the acts that you're alleged to have committed. This is a condition of your bond, and if you were to be suspected of violating this order, you could face additional criminal charges. So in a moment, my clerk's going to have a copy of that protection order. She's going to ask you to sign it and acknowledge that we're giving you a copy of it. And you can take a copy of it with you. If you have questions about what that order says, you will have a copy and you can read it as many times as you want to, or go over it with the help of an attorney, okay? So in a moment, my clerk will give you that. In this case, you have the right to have the help of an attorney. Are you planning on hiring an attorney or applying at the public defender to see if you qualify for a free attorney?
I am I'm appearing as a special appearance today, and
You're not appearing as a special appearance. You're appearing as Kenneth Phelan here standing in front of me in the courtroom. A special appearance is when you're an attorney.
Kenneth Phelan?
Mr. Phelan, if you want me to find that you're not Mr. Phelan, then I'll issue a warrant for your arrest for failing to appear. Do you want me to do that?
Well, that's what happened last time, but I don't.
Last time you didn't appear in court, so I issued a warrant for your arrest. So if you want me to make a finding that you're not stating that you're Kenneth Phelan, then I'll find that you failed to appear and I'll issue another warrant for failing to appear. So,
no.
I'm going to...
Don't do that, please.
At this point, it's best to drop the games before things get any worse, because pushing it further is only going to land you in an even bigger mess.
Okay, so you have the right to have an attorney. You're not making a special appearance. A special appearance is when an attorney appears without representing somebody to do something small in a case. As far as I know, you're not a licensed attorney. You're not representing yourself as an attorney. If you want to represent yourself not as an attorney, you're free to do that. But if you want to get an attorney's help on this case, I'm willing to give you time to do that. Would you like time to get an attorney's help on this case?
No.
All right. Are you going to be representing yourself without an attorney?
To jurists.
That's not a response. It's a yes or no question. Are you going to be representing yourself without an attorney?
I will retain all my rights as a person of the
All right.
United States.
Do you want to plead not guilty at this time and set your matter for trial?
Not guilty.
All right. We're going to go ahead and set this matter for a trial. I have an advisement that I need to give you because you're setting the case for trial without the help of an attorney. So I have a series of questions that I have to ask you. Do you understand that you have the right to be represented by an attorney throughout these proceedings?
So it's I'm being present in court. It's the state has
It's a yes or no question. You told me that you were exercising all your rights. One of your rights is the right to have an attorney. Do you understand that? Yes or no?
No.
What don't you understand about your right to have an attorney?
How so why this charge has brought me it's what am I so an attorney has to be, so if I want an attorney, then there's somebody else in the case that it would be, I just don't understand it, I guess.
Yeah, that's exactly what happens. When you rely on bad information from unreliable sources online, you end up walking into situations completely unprepared. And at this rate, you're not helping your case. You're heading straight toward a court-ordered competency evaluation.
All right, Mr. Phelan, are you under the influence of any controlled substances today?
Nope.
It appears to me that you are having difficulty formulating thoughts or expressing yourself in complete sentences. I'm concerned about your competency. So at this time, I am going to raise competency for Mr. Phelan. When a court raises competency because they are concerned that you are not competent in this case, that means that I believe that you're suffering from some sort of impairment of thought that allows you to understand these proceedings and participate in the proceedings. So the state of Colorado has to have an evaluation done of you by a doctor who is trained in impairments of the mental condition. And then that doctor conducts an evaluation and writes a report and tells the court what their medical opinion is of whether or not you are competent to proceed. So I'm going to issue an order that
I do not consent.
It's not something that you consent to. When I think that somebody's not competent,
Give a doctor a voice, not a person.
When I think that somebody is not competent, I am legally required to order a competency evaluation or make a finding that they're not competent and order that they participate in proceedings related to restoration to competency. It's not something I have a choice over. It's something that I'm legally required to do. And based on
the damages that you have caused me,
inability to formulate complete sentences or express.
This court has caused extreme damage for the past 2 years. I'm here under threat and duress. So that's all I have to say.
All right. So I am raising competency with regard to Mr. Phelan. My clerk of court is going to prepare an order to the Office of Behavioral Health directing that they appoint a medical doctor to conduct a competency evaluation. I'm also going to appoint a Bridges Court liaison. Right now, I don't know who the Bridges Court liaison is going to be because our normal Bridges Court liaison is on an undetermined duration of leave. And we have other Bridges Court liaisons from other parts of the state covering for her. But I need to provide the Bridges Court liaison with your contact information so they can get in touch with you. They will be coordinating with you when the evaluation will be completed, as well as any other services that you might want to have them help you with. On your bond paperwork, you listed a phone number of 541-848-7484. Is that your current phone number?
No, I don't use a phone number anymore.
All right, we need to have a way for these people to get in touch with you. Do you have an email address?
They can meet me in person.
Well, they need
They better
to
not
have
come
a
on
way
my
to,
private property.
they need to have a way to get in touch with you so they can make an appointment with you to meet you in person.
Well, I'm going to stay out on my private property and they ain't going to reach me.
What's your private property address?
Oh, it's private.
You're not doing yourself any favors here. Acting like this isn't going to help your situation. It actually increases the chances of being found incompetent and ordered to undergo evaluation and treatment, after which you'd still have to return and restart the trial from the beginning. On top of that, refusing to cooperate with a court-ordered competency exam can lead the judge to detain you without bond until the evaluation is completed, only making things more difficult for you moving forward.
All right, Mr. Phelan, it looks like the summons lists an address on State Highway 131. I'm going to have you return to court.
I moved.
Okay, I'm going to have you return to court on Friday morning, and I'm going to have the Bridges Court liaison here so that the Bridges Court liaison can speak to you directly about making an appointment with you. So I'll ask that you please appear on March 27th. That's this coming Friday at 9 o'clock in the morning. You can appear virtually or in person. I'll have the Bridges Court liaison here, and the Bridges Court liaison will talk to you directly about setting up a time to get in touch with you and meet with you, and setting up the evaluation. Okay.
The 29th?
March 27th, that's this coming Friday.
Okay.
At 9 o'clock in the morning. I'll ask that my clerk of court please indicate on the Bridges order the next day and time of the court hearing, and that Mr. Phelan will be available at that hearing for the Bridges Court liaison to get his contact information. All right, Mr. Phelan, you are free now to leave the courtroom, and I'll see you next either virtually or in person on March 27th at 9 o'clock in the morning.
Thank you.
Mr. Phelan, we do need you to sign that protection order, and then my clerk will make a copy for you.
I'm not signing it.
All right, if you refuse to sign it, you've still been advised of it. My clerk will write that you refuse to sign it, and if you want to get a copy of it, she can make a copy for you. But you have been advised on the record. My clerk will note on the form that you've been advised on the record, you've acknowledged the protection order on the record, and that you refuse to sign it. If you want a copy of it, you need to wait here so she can make a copy for you. For the record, Mr. Phelan has exited the courtroom. He has refused to sign the mandatory protection order, but he was advised of the protection order.
All right, this one was definitely a wild ride. It's honestly surprising how often these situations escalate to the point where courts have to step in and evaluate whether someone truly understands what they're doing or if something deeper is going on. Moments like these really highlight how important it is to rely on accurate information and stay grounded in reality. That said, if you enjoyed breaking this one down with me, make sure to hit like, drop your thoughts in the comments, and subscribe for more content like this. I'll catch you in the next video.
All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
His authorization and his legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent mayor.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
I do not this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
What we're seeing here is the judge trying to establish a basic identity, but the man refuses to answer directly and instead claims to be an attorney of fact. That immediately raises red flags. The judge stays patient but firm, making it clear that only licensed attorneys can represent someone in criminal court. You can feel the tension building as confusion turns into concern.
Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here. All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum law, citing certain Latin phrases, Dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on this case, which is set for trial tomorrow.
The man presents a document filled with complex-sounding legal language attempting to challenge the court's authority. From an outside perspective, this is a classic tactic often seen in pseudo-legal arguments. The judge doesn't let it slide. He interrupts, corrects, and firmly labels the approach as invalid. This is the turning point where the tone shifts from confusion to confrontation, and the judge makes it clear he's not entertaining this argument.
And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are in fact Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an article pre-trial?
To what?
Would that be an article pre-trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a possibility that you put a notice up there tonight, because we don't need you tomorrow, but we need you on February the 6th. Is that possible? General, we're going to need to set a trial date in July 10th.
July 15th.
I'm sorry?
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date And Mr. Aldridge, whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore deny whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
He firmly shuts down the interruptions, explains the authority of the court, and makes it clear that this behavior is wasting time. From a third-person view, this is where order is restored. The judge sets a new trial date and gives a final warning outlining real consequences if the defendant fails to comply. It's a decisive ending that reinforces how the legal system handles these situations. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.